You can guess I'm so delighted to be following Austin. How do I? Forwards and backwards. Okay, thank you. And in fact, I do play outside centre for Harpenden Forth, a little like a duck. So this really follows on from Tim Levine's presentation earlier today. He talked a little bit about how, from an investment side, how he looks at it as an investor in businesses. We act for sort of PE firms, VCs, individuals, entrepreneurs. So we're trying to pick out some kind of some issues for businesses when it comes to the legal side. And we've tried to do that in the, we're writing some articles in the Entrepreneur Country magazine where we're picking out particular case studies of transactions we've come up against and how we think that might help in terms of, it sounds slightly ironic for a lawyer to be saying this, to avoid actually excessive remedial costs. And that rather effeminate looking bag is meant to sort of show how on a investment round, what we're trying to do here is avoiding what we'll call cost leakage. This causes significant angst, if you like, for many of my investor clients. And the money falling out at the bottom is meant to signify that in some instances where you're making an investment round, there's not enough attention paid to some basic administrative tasks. Now, I totally understand that for many businesses, there's a business to run. You don't want to get involved in the legals too much, but there are some simple things that I think that can be done that will avoid some pain when it comes to when the investment round is being undertaken. Now, typically, a lot of the investors that we speak to on an investment round will do a slight over-provide in terms of allowing for certain costs over and above budget. But where they're excessive, you may find that investors may balk at that, or indeed may abort the transaction that you so badly need. Now, as you can imagine, after Austin's presentation showing you a picture of a company books, it's kind of difficult to do a gag that kind of goes with that, but so you can laugh if you want when you see a picture of a company book, but there we are. But all four of the case studies that I'm going to go through, and they're very quick ones, so don't worry about that, they're based on something so mundane as actually just completing your company books. So on a buyout, investors will want satisfaction that all the shares that they're buying have been, that they're buying all the shares and all rights to shares, such as options. On a more limited investment at an earlier stage, investors want confirmation of who the existing shareholders are and what shares they hold and who they're investing alongside. And all of this is actually determined by reference to the company books, nothing else. If the company books are not properly completed, and often we find company books with just the incorporation share in them because they're left in somebody's office gathering dust nicely, this can lead to, on every transaction that I've ever worked on, there is always a period in the transaction where you check the company books. And invariably, I can count the fingers on one hand of the occasions where they've been correct. And it does lead to costs and delay. And I think that's cost and delay that clearly it doesn't want to get in as an obstruction to what you're doing as legitimate business aims, because there's many other things I understand that need to be done. But if you can just devote time and attention to this once every 3 months or when you're thinking about granting options, I think it is a worthwhile investment of time. And in the company books, another set of boring forms, but hey, I'm a lawyer, there's 3 parts of the company books that I just want to, and this is what we see. So the register of members, now you might say, well, it's a form-filling exercise. Well, it is a form-filling exercise, but shares are issued as a matter of law when the names and details of the relevant shareholders are entered into the register of members. If your register of members looks like that, it's not very helpful when it comes to an investment round. And these ought not to be difficult questions. Gosh, I sound like a little bit scholarly here in terms of being a schoolmaster or something like that. But it is very important from an issued share perspective that the register of members is filled in. The same with transfers, the register of transfers, and if you've got options, again, I can count on the finger of one hand when there's been board meetings granting options and the register of options just doesn't exist. So that makes it very difficult for us, and the costs of remedying it, I think, are over and above what the costs are of actually getting it right to start with. Now, Many people have a sort of false impression of what a share certificate means. Shares in themselves are a bundle of rights. The owning of the piece of paper in itself is not particularly important as a matter of company law. However, what I would say, countering that, is what you don't want as an investor is somebody coming along who you're not expecting, either at the investment round, prior to completion, or afterwards, brandishing a share certificate. So if you can imagine that document in two, it's not halves, but the top third of it, which is the counterfoil. Even worse, what we find sometimes is the share certificate's been completed, it's been torn off. Usually, actually, what we find is just share certificates that are blank. But if it's torn off and the counterfoil isn't actually, the details aren't filled in. So if you haven't got a register of members that's correctly completed, and you've got a counterfoil that's blank, who are the owners of the equity in this business? Now, there we are. That's enough of that bit. Let's do some case studies, because law is a bit more interesting when you do real examples. So these two individuals are supposed to be founders of the business. They're not the real founders of this particular case study, otherwise it would kind of give the game away somewhat, I think. A typical round where you do, one of the first things that founders do maybe is, for CGT reasons and other reasons, is to try and get the family involved, family trusts, and then maybe get employees involved, and so employee shares. And then this company, what happened to this company, it wound up's probably a wrong word for a lawyer to use, but it ended up with 187 shareholders. The problem was that this business was only capitalized to the tune of between about 150 and 200,000 at the time. It had not even been through an A round. So when it came to looking at this business as an investable proposition, some of these 187 people, I'm just checking that the slide there is the ones here, some of them had emigrated, some of them have left the business on bad terms, and others were untraceable and the company books were incomplete. So what does an investor do about that? Well, one thing that he can do about that is, if the company had been attentive, so this presentation is about getting the company books right, getting the basic administrative tasks right, and also making sure that the constitution of your company reflects where that company is in the investment cycle of the business. So getting the constitution right means that in the event that those founders, if you went back to that original slide with two people in it, once they started distributing the equity outwards, they need to make sure that in their articles they had a drag-along right, so that the majority could control on an exit event or an investor coming in to control the fact that they could introduce that person to the business. Otherwise, even if an investor was found, how could you transact this business? And in terms of our firm acting, we just couldn't act for this client, and I don't think that the business unfortunately succeeded. So many of this document here, I'm afraid it's lots of documents, no funny stories and no rugby players, and there we are, but this document here is actually derived from the BVCA standard Articles of Association. The only thing that's important about this document, and we'll move on very quickly, is that here are some of the issues that you need to deal with in terms of once you start distributing equity. You need to control the transfer of shares. You need to control how employees are given shares. And when employees leave, how you get those shares back. We're very good at dealing with when employees leave and the compromise agreement for their terms as a matter of employment. But what about the shares? And one of my case studies goes into that example. So I'll be talking about two of those things in particular, which is number 24, the drag-along right, and the leaver provisions, which is what I just mentioned. So, a drag-along. Now, if our creative was good enough, we'd have this as a tug of war, or indeed a scrum. But in fact, that we could only find some scales, kind of more of a justice-related thing. So we have to talk about the balance here. So a drag-along condition is really where, as a condition for issuing equity beyond the initial founders, maybe to friends and family, maybe to employees, the founders will actually want the right to oblige those people to whom they've distributed the shares to sell them in the event of an investment round or a buyout. This is a normal provision, and I would expect A or B round investors to typically want to see this in an agreement first of all, and then post-completion they'll want to participate in this, and then therefore they will be dragging people along. So, and what happens, and one of the case studies I'll come to in a second, I will get to them in a second, I'm sorry about this, but one of the issues that we have is that where the drag-along is not appropriate for the circumstances, this goes back to my point earlier of making sure your constitution's correct and relevant to your business at that time of the investment cycle. In some instances where you can get the drag-along wrong, it actually is it turns it in favor of the people that you wanted to drag along, so it's actually ineffective. Now, this is the case, for example, in the business which went up to 187 shareholders. Even if they would have had a drag-along, it probably wouldn't have worked anyway. So, here's a case study. This is a real example, and let's call this business Drag Offer Limited. This is a drag-along right, and note that here, I hope it's in yellow, yes it is, the drag-along condition means that the buyer has to first make offers to all holders of shares. Now this business had 130 shareholders, so therefore to activate this condition, this business needed to comply with the Financial Services and Markets Act. For a business that wasn't particularly a large business, that's excessive, that's a huge cost, so we had to change this, this article. Now, that caused expense and delay. And one thing to always bear in mind is that it's better to do it in advance rather than at the time of the actual funding round. The reason for this is it's not always possible where you're changing an article. Remember this bundle of rights point that I made earlier about holding shares. If you're changing an article so that you can enforce a sale, you're actually doing that for the benefit of the selling shareholders. It's not for the benefit of the company as a whole. Typically, you can only change an article at the point of completion where it's for the benefit of the company as a whole. So in the event that the economic terms of this particular transaction benefited some people over and above the others, it's questionable whether you could change this article. And I'll come on to another example of this in this drafting. This was a much larger deal. This was an exit deal involving 3 VCs. And the interesting thing about this deal, I've not seen this type of article since. This is a more standard article. It doesn't require the offer to be made to all of the shareholders. You can see there in 14.1a, it should be in yellow, but there we are, that 75% of the people who, let's say, own the company, we haven't got the definition of voting rights here, can then drag along the rest. That's a more standard drag-along provision. However, such transfer is conditional upon the sale of the remaining outstanding securities. Securities is defined in the other yellow text as being including options. So, remember the bit about the register of options and the company books. In order for this drag-along to work, it is conditional upon knowing who the option holders are. In this business, the company did not keep a register of options. They had no contact details for the option holders. One option holder actually was dead, and we had to, in a telephone call from one of our junior associates, we were having to deal with the deceased in probate. Not the deceased in probate, that would be a neat trick, but you get the point. That would be a really good law firm that could do that. So the condition was non-fulfillable. On this deal, the transaction did favour certain shareholders over the other one, so we had to go to get Silk's opinion on this as to whether we could change the articles. This cost the client about 40 to 50,000 just to try and get this changed. So do keep, the company books are boring, but do keep control of them, especially where you're granting options. And this is the last one that I'll deal with. This is a particular case study. This is for a much earlier stage business. And this business had 2 founders, some employees holding shares, and let's call it Bad Lever Limited, or in this case, because of the graphic, Headless Lever Limited maybe. But so a small group of employees owning shares. Those employees then left. The compromise agreement dealt with their employment. I touched on this before, but it didn't involve their dealing in their shares. The directors thought, what are we going to do about that? Oh, let's just take the share certificates back. No, you can't just take the share certificates back because that means a cancellation of capital. Creditors get involved in things like that. The giving back of the share certificate didn't actually mean so much. Now, what happens then is that those persons who have left, they may be bad levers, angry with the founders of the company. They can participate in the equity, the voting, in the general meetings. In this case, they'd emigrated, so they weren't going to participate. But getting them back is not a straightforward thing to do. So there are some solutions to this, which is, one, make sure that if you've got employee shareholders, when they leave, deal with the employment and the equity at the same time. Secondly, when they subscribe, make sure they sign a 2-page document, a very simple document. It grants a power of attorney. And what that means is that every time you transfer shares, you need somebody to sign a stock transfer form. If they've granted a power of attorney in advance, then the directors can sign it on their behalf. So even though they've left the business, that means then that you can still deal in the shares. And I think that's roughly it. Am I out of time?
Well, spot on time.
So one of the things I wanted to touch on is that we're still seeing, if I've got another minute, we're still seeing bad levers and good levers traditionally as a matter of, we're rather lethargic about that in the UK, I would say, because we kind of say that bad levers are people who've breached their contract, which is a pretty heinous state of affairs, and good levers are not bad levers, so they're everything else. Good levers get market value when they exit on the company in terms of the shares, irrespective of where the company is in its life cycle and whether it can afford that, and bad levers just get the nominal value, which is what they paid for the shares. Increasingly, what we're seeing, probably since about 2007, I would say, as the sort of post-2007 correction has occurred, you're getting a lot of PE funds that are US-sponsored coming into the UK. It's becoming less binary. So you're getting this third type of lever, which is like a performance lever, which I think actually will catch on in the VC space and lower down in the pecking order. And that is that in the event that the managers have, say, for example, got certain targets that have not been reached, they may be paid out as a good lever, because a bad lever will just cover breach of contract. They may be paid out as a good lever, but they'll only be paid out at such time as the company goes through some kind of exit event, or it'll be deferred in some way. And I'm seeing a third category, if you like, evolving that will flow down, there's no doubt about it, where management will be set targets, and in the event they leave, this is when a VC becomes involved in the transaction, then they will be paid out in a slightly different way than what we're seeing in the market. So I just want to say that it's the company books. Please devote 20 minutes of your time over a 6-month period or something like that just to make sure they're right, because it will come back to bite on an exit event. Thank you.
Thank you very much.